The costs and impacts of a consent decree on police departments are enormous. There are literally millions of dollars spent on monitors and associated paperwork, and communities lose local control of their policies and procedures of their police department for years. The DOJ sought federal monitoring of the Phoenix Police Department based upon their report, but the report contains multiple false factual findings and provably incorrect legal analysis as well. This week, I want to discuss two topics. First is the false idea that I've heard circulating around Phoenix and other locations that a police department would potentially face lawsuits that could result in consent decrees or other oversight besides the DOJ process. And the second is further evidence that the DOJ's allegations are legally incorrect based upon a case that was just decided in the Federal District Court in Phoenix. I'm Steve Serbalik, and I'm a panel attorney for ASCOPS in Arizona. So on to that first topic, whether Phoenix is legally required to change their policies or procedures in order to avoid other court oversight. This is almost entirely false. Lawsuits against police departments and municipalities are common. For example, if there's an allegation that a police action injured a civilian, that can be brought under 42 U.S.C. Section 1983, the main federal civil rights law that exists and is used often. Critically, this law has a statute of limitations, a time limit on when claims can be brought. Generally speaking, they must be brought within 2 years of the harm caused. Additionally, the Ninth Circuit has made it clear that a finding of whether a department violated someone's civil rights is a fact-intensive question. So class action lawsuits based upon this law are uncommon and difficult to successfully bring. That hasn't stopped people from trying, though. When protesters brought a class action alleging that Phoenix policies or procedures were unconstitutional, the exact same allegations that the DOJ made, the plaintiffs failed. The courts evaluated Phoenix's policies and found them consistent with the law. And the Phoenix police use of force policies that were challenged for at least the past 5 years have been, every single time, found to be constitutional. On the other hand, the statute that allows DOJ actions isn't nearly as limited for fact requirements or for time requirements. All of this means, from a legal perspective, if individuals or groups try to sue a city, it's an entirely different set of legal factors. And consent decrees, or ongoing monitoring, is virtually never awarded as a remedy for a private party lawsuit. There are rare exceptions. For example, there have been circumstances where immigration issues have been remedied by ongoing federal oversight. But when it comes to evaluating use of force policies or actions, I can't think of a time where a federal court has issued ongoing police oversight that looks anything like what occurs after a DOJ consent decree. Second, just this week, protesters who engaged in unlawful conduct and were mentioned in the DOJ report had their day in court. They cited the DOJ report and alleged that their arrest was unlawful. The jury heard their claim and issued a verdict in favor of the lieutenant who was sued. In other words, Phoenix Police's actions in addressing those protesters who engaged in unlawful behavior was appropriate and lawful, despite the DOJ report claiming otherwise. Third, and most critically, here's what people in Phoenix should know. Police department policies and procedures should be based in the law. Officers need to comply with the U.S. Constitution, and the evaluation of their actions should be based on whether their conduct is objectively reasonable. There is pressure, and I fully believe it is unwarranted pressure, to change Phoenix policies to divorce them from the law. But restricting officers from using force when it's objectively reasonable is dangerous. It will result in officers hesitating to take action even when they should. And it will create millions of dollars of additional costs for the city when it encourages lawsuits not based upon the law, but based upon policies that are unrelated to legal requirements. It will put officers in Phoenix in horrible situations, where they faced losing their job after being put in a position that they believed required force to protect themselves or other members of the community. And it would discourage people from applying and remaining as Phoenix police officers. So boiling it all down, here's my suggestion. Everyone should obey the law. Policies and training should be consistent with the law and should be worded in ways that are supported by Supreme Court and Ninth Circuit opinions. This is how to best protect police officers and the public, both operationally and financially. If you have any questions or comments, please leave them in the comment section down below. Don't forget to like, follow, and turn on notifications. It really helps the channel grow. Be on the lookout for new videos. They come out every Sunday at 5:30 p.m. Arizona time. I'm Steve Cerbalic. Thanks for watching. Stay safe out there.
Negative.